In the 8th Judicial Circuit, Levy County, Florida, Jeremy Hale's in the building, motion denied. Vacate denied, case stays closed. Non-party masking, you already lost. Rule 1540 don't apply to you. Stand and gone, appeal time flew. 5 months late, now you cry and plead. Unauthorized practice, read the decree. Reopen? Nah, we shut it down. Hale's our supposition, king of this town. Order came down December 1825. Struck your emails, called the UPL vibe. Non-final order, judicial labor ain't done. Rule 1540, only for final ones. Hollifield, Garcia, Lawrence too. Appellate court said non-final, no go for you. Reserved jurisdiction, still enforcing the terms. Your motion's defective, confirm the concerns. Vacate denied, case stays closed. 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 Never a party, never intervened. Out-of-state lawyer trying to slide in the scene. No pro hots vice, no notice of appearance. Stranger to the record, pure interference. Kalai Sanchez, why take even more? Non-parties can't knock on the courtroom door. You had your chances, email, hearing the order. Sat on your hands, now you want a do-over? October emails, ex-part flow. Helping Preston while the court didn't know. Motion to strike here in December 17. You ghosted the spot, now you say unfair to me. Injunction in the order, immediately appealable. Rule 9130, 30 days unbeatable. Served on the portal, you had actual notice. Clock ticked out, now you trying to rewrite the story. No timely appeal, no reconsideration. Filed 5 months later with this weak one for a phony child. Waiver complete, finality reigns supreme. You slept on your rights, now live with the dream. Who's masking? Connecticut mass bar, not Florida license. Went a bit too far. Sanctions for Rubiel, 3rd degree felony vibe. Admonished and enjoined, now you wanna revive. Case stay for bankruptcy, but the order stands tall. Hale's got the W, watch the gavel fall. Vacate denied, reopen rejected. Motion to take, fully deceptive. Standing no, finality no, appeal no. Bruce Matskin, better luck in the next show. Deny it fall, affirm the decree. Unauthorized practice, let the record speak. Respectfully submitted, Shoche Law Group, July 2nd, committed fully sex.
Hey, everybody. Welcome in. Welcome in. I'm seeing some new faces. Welcome in. Yes, this is subscribers only. 5 minutes. You have to be subscribed for 5 minutes to be able to be in the chat. Hey, David. Hey, Tracy. We got a Kathy and a Sally. How are you guys today? Figure let people get in here. I went live a little early today just so people can come in, and I'll try to stay live until about 5-10 minutes before Megan is live, and you guys will be already redirected over to Megan once this is over. It's already set up and ready to go. Hey, Big Al. I'm hanging in there trying to stay cool, but it's not working. That's good, Kathy. That's good. Get some people in here, share this out. Let's get at least 20 in here before I pull this document up. Randy is totally destroying Duce. Big time. Hey, Teresa. I see you're over on Rumble. Yes, we are live on YouTube and Rumble. Oh, that's good, Big Al. It's been a crazy weekend for me, but I haven't really been home much all weekend. Oh, I don't need these. No, sadly, there was no fireworks in my town this year. It's a sad story. The head person of the fireworks that helps pay and put on the show passed away. What happened was the guy was looking down into one of the tubes and one of the fireworks went off unexpectedly. And yeah, just, I'm not going to say the rest because it's kind of nasty, but you can kind of picture what happened. So he passed away the day of the show as they were setting everything up. And what I've heard, it's some of those fireworks that they have recalled. I am going to copy and paste a link, though this is for a new window AC. What in the world's going on? There we go. Okay, there we go. Yeah, it is. Like Saturday, I was out in the heat all day long. I went swimming and then had dinner and watched the parade. After that, I came home and rested for a little while. Then I walked downtown to just get something to eat. Yeah, it is. It's sad. So they canceled the fireworks and said it will be rescheduled, but no, they didn't tell us when. We've got 11 people here. Share this out. Let's get at least 20 in here before I pull this document up. Yeah, I didn't really, wasn't going to do that because a lot of things say my town I live in. So, yeah, no, I'm not going to stream a parade here in my town. If I went to a different town, like I was, we were thinking about, but the rain in other areas was causing it to have to stay in town. But if I was in a different area, I would. but I don't want to stream the parade in my area until after some of these anti-eco, these haters are dealt with. Yeah, there's a lot of stuff that says my town on it in the parade, so. What do we got? 6 people here? 12? Looks like total. Come on in, everyone. Don't be afraid to say hi. This is a friendly stream. The more people in chat chatting, the better these streams get. And Tracy can agree with me on that. Am I right, Tracy? The more people in chat chatting, the better the stream gets. Hey, David. Welcome in. Welcome in. We've got Randy's motion on thumbnail case today. I will pull it up here in just a minute. Before I pull the document up, I'm going to play the song one more time for you guys. Oh, Teresa, that's because everyone's on YouTube right now. But what I'll do is, hang on here. Okay, there we go. Ooh, that's not fun. At least it was raining. Better than the heat. But I'm going to go ahead and play this song one more time, and then we'll get going on the document.
In the 8th Judicial Circuit, Levy County, Florida, Jeremy Hale's in the building, motion denied. Vacate denied, case stays closed. Non-party masking, you already lost. Rule 1540 don't apply to you. Stand and gone, appeal time flew. 5 months late, now you cry and plead. Unauthorized practice, read the decree. Reopen, nah, we shut it down. Hale's our supposition, king of this town. Order came down December 1825. Struck your emails, called the UPL vibe. Non-final order, judicial labor ain't done. Rule 1540, only for final ones. Hollifield, Garcia, Lawrence too. Appellate court said non-final, no go for you. Reserved jurisdiction, still enforcing the terms. Your motion's defective, confirm the concerns. Vacate denied, case stays closed. 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 Never a party, never intervene. Out-of-state lawyer trying to slide in the scene. No pro hots vice, no notice of appearance. Stranger to the record, pure interference. Kalai Sanchez, why take even more? Non-parties can't knock on the courtroom door. You had your chances, email, hearing the order. Sat on your hands, now you want a do-over? October emails, ex-part flow. Helping Preston while the court didn't know. Motion to strike here in December 17. You ghosted the spot, now you say unfair to me. Injunction in the order, immediately appealable. Rule 9130, 30 days unbeatable. Served on the portal, you had actual notice. Clock ticked out, now you trying to rewrite the story. No timely appeal, no reconsideration. Filed 5 months later with this weak report of phony child. Waiver complete, finality reigns supreme. You slept on your rights, now live with the dream. Who's masking?
submitted. Shoche Law Group, July 2nd, 2026.
All right. Let's pull this up here. Oh, hang on. The song's still showing. Hang on. Hang on here. Okay, there we go. All right, there we go. All right. We've got Randy's order on thumbnail case today. By the way, before haters say anything bad, this is a publicly obtained court document for public information, for public commentary, public to talk about. It is public information, free to use. And the song is AI created from this document. I'm going to get that spew before I even get started because you know how the haters are. And they like to watch. And yes, today is a day I am trying to raise money for my air conditioner still. Only money that's been raised is $30 out of $550 that I need to be able to get a new air conditioner. But for now, we've got defendant Jeremy Hales, response in opposition to non-party duce, special and limited appearance motion to reopen case for limited purpose and motion to vacate order, granting motion to strike unauthorized communications and for sanctions for unauthorized practice of law. Randy lays it down hard. And Louis is destroying Deuce in this document. Like, we should have heard from Levy County today back on this document. But no, they didn't. Levy did not respond. As far as I know, let me check though, and just see if something popped up last minute. Because I checked it about 6 o'clock, there was nothing, but things like to pop up real quick. And yes, Lynette's LP's depot is tomorrow. No ifs, ands, or buts about it. Yep, nope, nothing from the judge. Just as I thought. All right. We got defendant Jeremy Hales by. I'm just instead of saying Jeremy's full name, I'm just gonna say JH, just to make it quicker. Because this is a long document, I will probably skip areas just to get through it. Defendant JH, by and through undersigned counsel, respectfully submits this response in opposition to non-party duce special limited appearance motion to reopen case for limited purpose and motion to vacate order, granting motion to strike. Hey, Dina! Unauthorized communications and for sanctions for unauthorized practice of law. Mr. Duce, an out of state attorney who was never party to this action, never admitted pro hack vice and never appeared before this court. Yeah, Duce never submitted anything stating he was helping write documents. Never. The way the court actually did find out was because of Stark's deposition, where Stark said Duce has been writing stuff, and Stark knew nothing about what was going on in the case. An out-of-state attorney who was never a part of this action, never admitted pro hack vice. Okay, I read that part. Sorry, and never appeared before this court. Yeah, he Duce never showed up there. Now seeks to reopen this case and vacate December 18th order. An order entered by this court. Mr. Duce motion should be denied. Denied. It should be in its entirety because it is procedurally buried on multiple independent grounds. So all Randy's saying that Duce is burying himself. By Duce doing that, he dug himself a bigger hole and covered himself up. Okay, I need somebody to make me a small shovel. Just an itty bitty shovel to eat for props. Hang on one sec here, sorry. Thank you to the donation for the window air conditioner. Every little bit helps. I will not say names just to protect you. First, Florida rule of civil procedure, which is this number right there. Sorry, I don't mean to click it like that. Does not apply to non-final orders. And the December 18th order is non-final because it did not terminate judicial labor in the underlying case. The order addressed only Duce's unauthorized practice of law without resolving any claims between actual parties to the Preston v. Hales litigation because the order did not constitute an end of judicial labor and expressly resolved jurisdiction to enforce its terms. It is non-final and therefore non-subject to relief under the rule. Multiple Florida appellate courts have constantly held that rule. The numbers applied to only the final judgments. Decreases, orders, or proceedings and motions filed under the rule cannot be directed toward non-final orders. See if anyone said anything. All right. I will stop after every paragraph to check your guys' chats. Since I am by myself, it's I got to do chats and read at the same time. So, second, Mr. Duce lacks standing as non-party, who never, who never intervened in this action, therefore cannot even invoke rule. Woo-hoo-hoo. Florida law formally holds that hang on. Okay, that holds that non-parties are strangers to the record who lack standing to seek relief from orders entered in cases to which there were non-parties. Non-parties must intervene to establish standing, and failure to do so bars subsequent attempts to challenge orders. Mr. Duce had multiple opportunities to establish standing by intervening in the case. One, after he exchanged multiple emails with the court. Two, when he received notice that of proceedings at the December 17th hearing. And or three, after the order was entered, but he took notice of these steps instead. He waited 5 months, 5 whole months, and then filed a motion to vacate, appearing only specially to challenge the order. Yes, Bruce waited way too long to do this stuff. Is the chat on the screen too big? Let me see if I can make it smaller. That's probably the best I can get it, unless I turn it off. Hey, Dina. How are you doing, Dina? Is my chat frozen? So I'm catching my breath for a sec on reading because it is a lot of reading. Would you guys prefer me to turn the chat off on the screen or keep it on? That's up to you guys. Because I do have people on Rumble too. I'll let you guys tell me. Turn chat off on the screen or keep it on? Oh, hang on. I'm clicked the wrong thing. Leave it on? Okay. I will make it a little bit bigger, the words on it, though. There we go. There we go. All right. Third, Mr. Matson waived his right to challenge the order by filing to pursue timely interlocutory appeal under Florida rule of appellate procedure. In this rule right here, the December 18th order contains an injunction that was immediately appealable. Mr. Duce was served with the order and had actual notice of it, yet he failed to file notice of appeal. So Bruce Duce never appealed the order within the requested 30-day period. So he never filed a response or appealed it. He had every right to appeal it, but he didn't. So it's his own fault that he's in this predicament now. Instead, he waited approximately 5 months before the filing an improper motion under the rule. This failure to pursue timely interlocutory appeal concise waiver and bears his current motion. Florida law does not permit parties to use the rule as a substitute for timely appeal or to circumvent appellate deadlines. Exactly, Tracy. Sucks to be him. Fourth, reopening the case to consider motion filed under inapplicable procedure rule by non-party who never intervened would undermine finality of the order and is inappropriate. The matter as Duce is closed, and Duce had proper remedies that he failed to pursue. Allowing him to reopen the matter now would reward procedural default and render appellate deadlines meaningless. Ha ha ha. For the reasons this court should deny Duce's motion without reaching the merits of his arguments. And that's true. It needs denied. We should have heard from the judge today, but no. Hopefully we hear from the judge tomorrow. Statement of facts. Let me see if... Okay, yeah. This is definitely a part I'm going to go through. Hang on, I'm just looking to see. Okay. This one's pretty long, this part. Yep, exactly. He knows better. All it is him trying to delay things and make Jeremy pay more money. With this, Randy is putting a stop to that. This document right here is putting a stop to all that nonsense. So Bruce can't delay things and cause Jeremy to pay more money. Hello, great grand. How are you today? Welcome in. I'm seeing some new names here today. I'm liking this. One's watching, don't be afraid to chat. We are a friendly chat. If people cause problems, they will be removed from this chat. I will not let people harass or bully people in my chats. This is a friendly stream. That's good, great. Sorry. Uh, uh, and one's just coming in. There is a link post pinned to the comments for donating towards to help me get a brand new window air conditioner for my apartment. My window AC is not cooling enough, and the Freon is shot in the air conditioner. It's barely working. So there's a fundraiser to raise money for me to get a brand new air conditioner. Giving it a sec to let people chat. Any questions or anything so far? Take a little bit of breather. I will probably end this at about 5:05. Well, 8:05, 8:10ish, in about an hour. Yes, exactly, Tracy. And until I raise the funds for my air conditioner, the fundraiser will be on every live stream until I have the $550. I don't know who else I could ask to share it out to help me raise the money. If any of you are in any Facebook groups that would allow links, post it in there or share it with your family and friends for me. I'd appreciate it. But if you do post it in groups, make sure you ask them permission. And there's one group you do not share it in. It's the one that a certain DJ in Australia owns. I do not want that link in that group. There's reasons why. I will let you guys peek at the fish for a sec, though. I fed them right before I started, so they're good on food. All right, we got statement of facts. This action was filed by plaintiff LP against defendant JH, George, Larry, and I'm not going to say this name. I need to redact it. Because there's a reason why. I'm trying to see how you do that. Thank you, Tracy. That's a good one. Sorry, I'm trying to. There we go. There's a reason why I'm doing this. Alright. And the certain person in the case, which is the thumbnail case, MX. Okay, that's part of that case number. Okay. Duce is an attorney licensed to practice law in Connecticut and Massachusetts, but is not licensed to practice law in Florida. Duce was never a party in this action. Wait. Yeah, in this action was never counsel of record for attorney any party, was never admitted pro hac vice in this case, and never filed a notice of appearance. And that's all true. Everything is true. In October 2025, Duce sent multiple pro ex parte emails to this court in this case, including emails dated October 6th, October 7th, October 9th. These emails concern matters pending before this court in underlying action at the time. Plaintiff LP was appearing pro se following the death of her Florida counsel, Stark, in August. On October 23rd, defendant Hales Jeremy filed a motion to strike unauthorized communication and for sanctions for unauthorized practice of law. The motion alleged that Duce, and as an out of state attorney, not licensed in Florida and not admitted pro hac vice, has sent ex parte emails to the court containing legal arguments on behalf of LP and may have prepared legal documents. Hang on. Sorry, some things going off. Oh. Uh, Prepared legal documents in this matter. The motion sought to strike all communications and legal documents attributed to Duce, prohibited further communications with the court and or parties until he was properly admitted pro hac vice or associated with Florida counsel. Exactly, Tracy. Hey, what's hey, what's okay? Where was I? Okay, counsel requires LP to wait. Where was I at? Okay, require LP to identify any non-licensed Florida attorney who drafts paperwork on her behalf and refer the matter to the Florida bar for investigation. It's what the court did and what Jeremy asked. It's okay, Teresa. On October 24th, notice of eventual hearing was filed. setting the motion for hearing on December 17th at 1:30 p.m. before Honorable Robert Grobe, which sadly Robert Grobe has retired. The Certificate of Service of Non-Evidentiary Hearing certified portal service only on Miss LP. Pro se at the email address registered with the portal. The notice did not identify Duce as a person served, did not list service address for him, and did not certify any method to service on him. So it means that there was no need to serve Duce for that stuff. Duce was not supposed to be at that hearing. Only LP was supposed to be at that hearing. On December 5th, counsel for defendant Jeremy, sent Duce a private email attaching the motion and notice of hearing. This email was not partial service. Formal email service under the Florida Rule of General Practice in Judicial Administration, a summons, a subpoena, or court-issued order to show cause. It's getting good. The hearing proceeded as scheduled on December 17th. Before this court, Mr. Duce did not appear. He did not show up, either personally or through counsel. No transcript or recording was made of the hearing because they didn't have to make a transcript or a recording. It wasn't required. On December 18th, this court entered an order granting motion to strike unauthorized communications and for sanctions for unauthorized practice of law. The order found that Duce is not licensed to practice law in Florida and has not been admitted pro hac vice in this matter. The order further found that Duce engaged in communications with the court and Miss LP in this case, including emails dated October 6th, 7th, and 9th. Wow, this is a long paragraph here. Let me get it. I'm going to take a drink real quick. Yep. Dang it. Sorry. Which can constitute the unauthorized practice of law. A third-degree felony. Third-degree felony. Jail. Meaning jail for Duce. Florida statutes referable for prosecution to the Florida Supreme Court. Which, yes, it was sent. Everything was sent to the Supreme Court to pursue and basically lock Duce up. The order struck all communications, including emails and legal documents, sent or prepared by Duce, in this case, from record. It means remove, stricken, taken off the court record completely. Not usable. The order admonished Duce, which removed where he can't do anything. Duce, 4, engaging in unauthorized practice of law in Florida without proper admissions to the Florida bar or pro advice admission in this case. The order enjoined Duce from further communications with the court until properly admitted pro hac vice to the rule number of Florida rules, the Florida rules of general practice in judicial administration are associated with Florida Council, who actively participates in the matter. The order also directed plaintiff LP to identify to the court and all parties names of anyone licensed to practice law in Florida who gives legal advice to her in matters before the court or drafts paperwork on her behalf, which is then submitted to the court in the future. Finally, the order reserved jurisdiction to enforce terms. Means in which LP never submitted anything stating who's helping her write documents. And there is somebody still helping her write documents. There is somebody. And she has not informed the court about it. I have no clue yet, Tracy. I haven't heard anything about it. Well, if you listened to Jeremy last night, Jeremy was saying there's other hearings coming up for Duce in Florida. So it's already in the system for him. So there is some other hearings coming for Duce. He's done for. I really think he's going to jail for this stuff. The certificate of service on the December 18th order shows that copies were furnished via filing with the Florida courts e-filing portal on December 18th to Randy LP Pro Se and Duce at his Massachusetts address. See, he was okay. I'll take that back from earlier. Duce was informed about the hearing, but decided not to show up. The underlying case between the parties remain open, and as this court has specifically granted defendants' motion for entitlement to sanctions. Yes, and they did. LP will be owing Jeremy money for this stuff. As per section number Florida statutes retain jurisdiction to determine the amount of reasonable attorney fees for the sanctions for filing the frivolous litigation. No, I don't think so, Tracy. Because Jeremy said that Sunday there's some Florida hearings for Duce coming up about all this. It's not only the hearing that's scheduled for this case, it's other hearings that I don't have the dockets for. And I don't think I can get them. I don't think I can get Supreme Court documents. As Miss LP is currently pursuing bankruptcy in this court, this court cannot proceed on a hearing to determine the amount of sanctions until the bankruptcy case is complete. The case is currently stayed as a result. Teresa, I think it is going to be jail for him and removal of his licenses. Yeah, Jeremy said it last night. Sometimes you got to listen closely because he talks soft about certain things. On May 14th of this year, approximately 5 months after the December order was entered, Mr. Duce filed an instant motion appearing solely for the limited purpose challenging the order. Mr. Duce seeks to reopen for limited purpose of vacating order or alternatively narrowing it to remove all the findings unauthorized practice of law. Felony. Characterization. See, felony. Randy's using the word felony because third degree felony is what Bruce is going to get. Characterization, admonishment, and injunction. Mr. Duce asserts that the order has been submitted to Connecticut bar authorities in support of disciplinary grievance against him. Yep. The argument part I'll skip because it just goes on over a bunch of rules and other case stuff. Wow, it's only... Oh, it's about 30 minutes. Okay. Okay, there we go. Well, now that's... Hang on here, sorry. If it's making you dizzy, I'll take it off the screen. Yeah, he will be at Massachusetts and Connecticut in person. They're going to make him be there. They know about all this too. This stuff isn't hidden from them. They've been told. I'm trying to get to some good parts here. This is a long document. A lot of it has like other case laws in it, in that. Let's see, what's this one? Okay. Here we go. That's a part that definitely need to cover. I think I'm going to play this song for you guys and take just a minute break. Just so I can stand up, move around for a minute, and stretch. I mean, 1 sec, though.
In the 8th Judicial Circuit, Levy County, Florida, Jeremy Hale's in the building, motion denied. Vacate denied, case stays closed. Non-party masking, you already lost. Rule 1540 don't apply to you. Stand and gone, appeal time flew. 5 months late, now you cry and plead. Unauthorized practice, read the decree. Reopen, nah, December 1825. Struck your emails, called the UPL vibe. Non-final order, judicial labor ain't done. Rule 1, fine 40, only for final ones. Hollifield, Garcia, Lawrence 2. Appellate court said non-final, no go for you. Reserved jurisdiction, still enforcing the terms. Your motion's defective, confirm the concerns. Vacate denied, case stays closed. Vacate denied, case stays closed.
Vacate denied, case stays closed. Vacate denied, case stays closed. Vacate denied, case stays closed. Vacate denied, case stays closed.
Never a party, never intervened. Out-of-state lawyer trying to slide in the scene. No pro hots, vice, no notice of appearance. Stranger to the record, pure interference. Kalai Sanchez, why take even more? Non-parties can't knock on the courtroom door. You had your chances, email, hearing the order. Sat on your hands, now you want a do-over? October emails, ex-part flow. Helping Preston while the court didn't know. Motion to strike here in December 17. You ghosted the spot, now you say unfair to me. Injunction in the order, immediately appealable. Rule 9, 130, 30 days unbeatable. Served on the portal, you had actual notice. Clock ticked out, now you trying to rewrite the story. No timely appeal, no reconsideration. Filed 5 months later with this week one portal for any child. Waiver complete, finality reigns supreme. You slept on your rights, now live with the dream. Who's masking? Connecticut mass bar, not Florida license. Went a bit too far. Sanctions for Rubiel, 3rd-degree felony vibe. Admonished and enjoined, now you wanna revive. Case stay for bankruptcy, but the order stands tall. Hell's got the W, watch the gavel fall. Vacate denied, reopen rejected. Motion detained tape, fully deceptive. Standing no, finality no, appeal no. Bruce Matskin, better luck in the next show. Deny it full, affirm the decree. Unauthorized practice, let the record speak. Respectfully submitted, Shoche Law Group, July 2nd, Committed fully sex.
All right. And we're back. Thank you. I just needed a breather and a quick break for a sec. All right. We've got Maskin waived his rights to challenge the order by failing to pursue intellectually appeal. He failed to appeal. Even if rule blank blah 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 applied to December 18th order, and Duce had standing to challenge it, which Duce could have challenged that, and he didn't, which he does not. I think Randy meant to say which he did not, but Duce waived his right to challenge the order by failing to pursue the proper remedy, intellectual. Okay, I can't really say that word, so I'm just going to appeal under Florida Rule of Appellate Procedure. The order contained as injunction that was immediately appealable. Mr. Duce was served with the order. He and had actual notice of it, yet he failed to file notice of appeal within required 30 days. Period. Instead, he waited approximately 5 months before filing improper motion under rule. This failure to pursue timely appeal concise U.S. waiver and bears his current motion. December 18th order contains an injunction, and it does. The December 18th order expressly states Duce is hereby enjoined from further communication with the court until properly admitted pro-act advice pursuant to the rule of Federal Rules of General Practice, Judicial Administration, or associated with further counsel who actively participates in the matter. This language bogusly establishes an injunction. The order prohibits duce from engaging in specific conduct, communicating with the court unless and until he satisfies certain conditions. This is questionable. Wait. Okay, I'm having trouble with that word for some reason. Oh well. Function of an injunction to restrain a party from taking particular actions. I don't mean to click the page every time. Every time I click it, it highlights everything, and I'm trying not to. Oh, there we go. I'll just use my keyboard instead of the mouse. Okay. Florida Rules of Appellate Procedure provides for immediate appeal of injunction orders. Immediate, right away. Not 6 months later, 3 months later, right away. 30 days. Florida Rules of Appellate Procedure authorities appeal of certain non-final orders to the District Court of Appeal. Specifically, rule permits immediate appeal of non-final order that grant continue, modify, deny, or dissolve injunctions, or refuse to modify or dissolve injunctions. The Florida Constitution grants district courts of appeal authority to review non-final orders to the extent provided by rules adopted by the Supreme Court. In rule provides the authority of for orders involving injunctions, city of New. Okay, that's another case. Here we go. The December 18th order fails squarely within this category. Oh my. Randy used the word squirrely. Oh my gosh. Good one, Randy. Within this category by enjoining Mr. Duce for communicating with the court. The order granted an injunction. This made the order immediately appealable under the rule, which Duce never appealed. Regardless of whether it was a final order, okay, I cannot pronounce that word for some reason. Appeal was Duce proper remedy to challenge the injunction. The notice of appeal must be filed within 30 days. Not 3 months, not 6 months. What's it say? 30 days, Duce. You're late. Pursuant to rule of appellate procedure. The jurisdiction of appellate court must have invoked by filing a notice of appeal. within 30 days of rendition of the order to be renewed. This 30-day deadline is mandatory and jurisdictional. The time limit begins to run from date of the order of the from the date the order is rendered, which in this case was December 18th. So he would have had till January 18th or 19th. Day before January 18th or the day after. Somewhere around there. Duce failed to file timely notice of appeal. The undisputed facts establish that Mr. Duce failed to pursue timely appeal. The order was entered on December 18th. The order was served on Duce via e-filing portal on December 18th. Duce did not file a notice of appeal within 30 days of the order. Duce did not file any motion for reconsideration in the trial court on May 14th. Wait, okay. This is a new thing. On May 14th, approximately 5 months after the 30-day deadline, Duce filed his motion to vacate under the rule. The 30-day period for filing notice of appeal expired mid-January. Mr. Duce's motion filed nearly 4 months after the deadline expired. So it was 4 months after the deadline. Cannot rescue his lost appellate rights. E-motion for reconsideration. Non-final orders do not tell the appeal period, unlike authorized and timely motions directed to a final order. Motions for reconsideration or rehearing of non-final order are unauthorized and therefore do not toll the 30-day time limit for filing notice of appeal. Even if Duce had filed a motion for reconsideration of the December 18th order, which he did not, such motion would not have extended his time of appeal. The 30-day deadline would have continued to run, and his failure to file notice of appeal within that period would still constitute waiver. The fact that Duce filed no motion for reconsideration and simply allowed the appeal period to expire makes his procedural default even more egregious. Igorous. I hate to say that, Tracy. He has been in trouble with, not in Florida yet, but he's been in trouble in, it was either Connecticut or Massachusetts. One of the two states he was in trouble with the bar. That's why he has that that little mac and cheese case, and has been trying to push that because he has been in trouble. Failure to pursue timely interact. Okay. Appeal consult. Insinuates waiver. Okay. Duce failure to pursue timely Okay. Appeal insinuates, I guess, waiver of his right to challenge the December 18th order. He had actual notice of the order as it was served on him via e-filing portal. Okay, that's a repeat. Okay, now we're just repeating stuff. Okay. Okay, here we go. Here's the good part. Conclusion. For the following reasons, defendant JH respectfully requests that this court enter an order denying non-party duce special limited appearance motion to reopen case for limited purpose and motion to vacate granting motion to strike unauthorized communications and for sanctions unauthorized practice of law in its entirety. They want Duce's motion denied, declining to reopen the to challenge an order he failed to timely appeal, which he did fail to timely appeal, affirming the December 18th order granting motion to strike unauthorized communication for sanctions and unauthorized process of law, finding that Mr. Duce motion is procedurally barred because Florida rule civil procedure does not apply to the non-final December order. Duce lacks standing as a non-party who never intervened in this action. C. Duce waived his right to challenge the order by failing to pursue timely interactually appeal, and D. Reopening as inappropriate under these circumstances, granting such order in further relief as this court deems just and proper. Yep, it should be denied. Oh, give me one sec. Okay. Certificate of service. I did not redact any emails. That's why I'm just being quick. And that's it of that order. I did skip a lot just because it's repeat and a lot of it's explaining details of different cases that happened in the past. Do you want to save? Yeah, I'll save it. All right. There we go. All right. We can hang out and talk, guys. I will check and see if there's anything that. Whoops. I will check and see if anything popped up while we were looking at all that. And I might try to pull up a post from LP. We've still got about 25 or so minutes before Megan's live. There's nothing on the federal courts. Yep. It's 7:51. Nope, nothing new popped up. Let's see. Did anyone see LP's YouTube post today? I'm actually not going to pull it up because I don't want them trying to copyright strike me. But one of her posts, it was 10 hours ago on YouTube. It's 7 o'clock here, Tracy. I'm Eastern time. Barrett Jones, welcome in. Yes, you should join tonight. I'm not going to pull it up because I don't want her trying to strike me, but I'm just going to read the short one. In my deposition, I will tell the truth, the whole truth, and nothing but the truth. I have contrary, CONTRARY, to the lies about my character, have never been a liar. I will not be threatened by anyone. That's one of her posts. And there are not lies about your character that everyone's been saying, LP. All the truth has been said out. You're the one that... LP is the one that's lying about everything. And I bet you Jeremy uses that post in the deposition. I bet you it'll be in the deposition. Yeah, she never does tell the truth. She's a complete liar. Straight out liar. And the other post she did, it's a long one, and yeah, I'm not going to get into that one. But yeah, she... And did you guys hear, though? Hear Jeremy say that if LP is caught lying in the deposition, she will go right to jail while in the deposition. Jeremy said that last night on the live stream. And none of the antis tell the truth at all. But Randy and Jeremy know the truth about everything. And if LP is caught lying tomorrow, she will go right to jail. No ifs, ands, or buts about it. And the way he sounded, they are going to be taking away all electronic devices too before the depot starts. There will not be any electronic devices in the deposition whatsoever, except for the court stuff. Oh, they will. They have to. And this will be court deputies. This won't be Levy County sheriffs. It'll be actual court deputies at the courthouse. So totally different set of, yeah. Most likely she will be in jail by the end of the day tomorrow. And I'm gonna laugh and smile and be like, "Told you so," and keep going on in my life and keep getting these court documents for the cases and everything. And after, when cases are over, I'll find other stuff to do. I can gain. There's other stuff I can do than just the court documents. I'm not much into going into starting reading like other cases for other people, and I'm not going to get into that stuff. Just not my thing, really. But by the end of the day tomorrow, most likely she's going to be in jail. And hopefully the courthouse does something about John sitting there with the little kid in the car. Because it's going to be too hot for that. Oh, she will try to plead the fifth, but it's not going to be allowed. She won't be able to do all that. She has to tell the truth, nothing but the truth this time. Because Randy and Jeremy have all the correct evidence to prove she's not telling the truth. She knows all the information. She can't hide it. And like Jeremy said last night too, the trustee already offered Jeremy to buy the property. I already figured Jeremy was going to say no in the first place because Jeremy said he doesn't want that property. Which I don't blame Jeremy for not wanting that property. Yeah, exactly. That kid does not need to be in the heat. I'm not going to say names. I'm just going to say the kid. But she does not need to be out in the heat whatsoever. And you heard Jeremy too. If John tries to come into the deposition, he will not be allowed in there whatsoever. And I was saying that last week that he won't be able to go in, and I was right. The only people allowed in the deposition are 5 people: Randy, Jeremy, George, LP, and her lawyer. That's it. And she's not going to be allowed to. That is a law in Florida. You cannot have a kid in a hot car. And she's not going to be able to get sympathy or anything this time. And most likely, there's going to be a deputy standing in there the whole time. Plus, like Jeremy said, there's going to be a judge in there watching everything too. So, it's going to be a lot of pressure on her. No. They won't let him enter because he's not allowed in there. And you can't go in a courthouse and just sit inside a courthouse. All courthouses now, you have to go through metal detectors and that. They won't let somebody just go in there and sit. And with that, the courthouse where they're at is not that big of a courthouse at all. So they don't have the room for somebody to go in there and just sit. So he's going to be outside in the car no matter what. Unless LP does the right thing and leaves him and her back at home where they're supposed to be. But I doubt that'll happen. But guys, it's going to be about 10 minutes or so till Megan is live. So let's go ahead and call it a day. And don't forget, if you're able to help with the air conditioning fund, please help donate. I'd appreciate it. Because I really need an air conditioner badly. And everyone, you have a good weekend. Well, good evening. I will see you guys tomorrow and in chats tonight. You take care. I'll see you on Megan's Live here in a little bit. Bye, everyone. I'll play the song on the way out. And you will go
In
right
the 8th Judicial Circuit, Levy County, Florida. Jeremy Hale's in the building, motion denied. Vacate denied, case stays closed. Non-party Matskin, you already lost. Rule 154, they don't apply to you. Stand and gone, appeal time flew. 5 months late, now you cry and plead. Unauthorized practice, read the decree. Reopen, nah, we shut it down. Hale's our supposition, king of this town. Order came down December 18, 25. Struck your emails, called the UPL vibe. Non-final order, judicial labor ain't done. Rule 1540, only for final ones. Hollifield, Garcia, Lawrence too. Appellate court said non-final, no go for you. Reserved jurisdiction, still enforcing the terms. Your motion's defective, confirm the concerns. Vacate denied, case stays closed. 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 Never a party, never intervened. Out-of-state lawyer trying to slide in the scene. No pro hots, vice, no notice of appearance. Stranger to the record, pure interference. Kalai Sanchez, why Tate and more. Non-parties can't knock on the courtroom door. You had your chances, email, here in the order. Sat on your hands, now you want a do-over. October emails, ex-part flow. Helping Preston while the court didn't know. Motion to strike here in December 17. You ghosted the spot, now you say unfair to me. Injunction in the order, immediately appealable. Rule 9130, 30 days unbeatable. Served on the portal, you had actual notice. Clock ticked out, now you trying to rewrite the story. No timely appeal, no reconsideration. Filed 5 months later with this week one point of phony child. Waiver complete, finality reigns supreme. You slept on your rights, now live with the dream. Who's masking? Connecticut mass bar, not Florida license. Went a bit too far. Sanctions for Rubiel, third degree felony vibe. Admonished and enjoined, now you wanna revive. Case stay for bankruptcy, but the order stands tall. Hale's got the W, watch the gavel fall. Vacate denied, reopen rejected. Motion to vacate, fully deceptive. Standing no, finality no, appeal no. Bruce Matskin, better luck in the next show. Deny it fall, Respectfully submitted. Shoche Law Group, July 2nd,